So why don't we open this up a little bit? I'm going to place this microphone on that stand, and I encourage people to line up behind it for brief questions. In the time we have left, we'll take one at a time to start with. I don't think there's any priority if you're a defendant in an MPAA-sponsored suit. You just have to wait in line like everybody else. And we'll also alternate in the line with questions that are coming through the question form that the online viewers...
Now, why do I believe that as a result of these questions, I will not be universally beloved by anybody?
Well, each of you seems to have a thing about being hated. I assure you, you're both very nice people. So let's see what we can do.
Hi. My name is Emmanuel Goldstein from 2600 Magazine. I don't know if you know me, Mr.
Yes.
Valente. But
MPAA defendant, right? All right, but you were...
You guys just won a big lawsuit against us. Congratulations. It's cost the Electronic Frontier Foundation about $1 million so far. I know it's cost you guys about $4 million. I know you tried to make us pay for that, but the judge didn't want to do that. My question, though, basically it revolves around conceptions, because while I lost the lawsuit, I don't think I've yet learned the lesson, because I thought I knew what a thief was. I thought a thief was someone who stole something with intent to steal something, but I learned that it's not necessarily that way, that a thief is actually somebody who writes software that can be used by somebody who wants to steal something. And then I learned that not only is the person who writes the software a thief, but somebody who calls attention to the software is also considered a thief. Because at 2600, that's what we did. We had a website that pointed to the program, or the source code, that was used by someone to play a DVD on a Linux system, which was interpreted by the MPAA as thievery. I'm just a little confused as to how many different levels this can go to. With the help of the Digital Millennium Copyright Act, which I'd also like to know why I shouldn't be scared to death of this thing, it seems that any time somebody tries to figure out technology, they can be guilty of thievery if it's ruled that they shouldn't try to figure that out. I'd also like to know, at the trial, I saw people outside the courtroom, literally across the street, selling videotapes of movies that had just come out that day. And we told MPAA people this, the lawyers on their side, we told the media this, and nobody cared. And those people are still there to this day. And somehow I'm a thief. So just clear up my confusion, please. Thank you.
What was the question?
Well, the question is, how is somebody who publishes information on a website about a computer program that shows how encryption has been hacked is a thief?
Well, I suggest you read Judge Kaplan's decision.
Oh, I'm very familiar with it.
Well,
if he was here, I'd be asking him the same question. But
again,
since most of it was word for word what you guys said, I'd like to know the answer.
You know what? It's the American judicial system at work. He looked at reverse engineering. He looked at security. He looked at fair use. He threw them all out the window. Said they had no bearing. They violated the DMCA. You cannot circumvent encryption. That's the law of the land. Now, if you want to change the law, you have to go to Congress to do it. I don't have a vote in Congress.
Well, the DMCA did change the law, and that's the thing.
Well, that's right.
Congress voted on this with an unwritten vote, a voice vote, unanimous, everybody agrees
But the
that
law...
you cannot circumvent encryption anymore. And I'd just like to know why it's so important to control how people use technology. Why is it important that I not be able to skip over commercials on a DVD? Why is it important that in the future with HDTV that the same kind of controls be in place for recording programs and for playing back programs? I don't think a lot of people are aware of this yet, but that is what is going to happen. And the DMCA is what's going to make it possible. I'd just like to know what the intent behind this was. I mean, wasn't it good enough already before for you guys? I mean...
Well, I'm glad I skip over commercials all the time.
Well, you won't be able to, and if you try, you'll be breaking the law.
That's my little controller. I'm saying again to you, no laws are lapidary. They're there to be changed or revised if the circumstances benefit the majority of the American people. So I'm saying if you have a quarrel with the DMCA...
So, Jack, sorry, behind you. Let me just ask to focus it a little bit.
You think it's been unfocused, according to...
I do too. A personal view on the issue? Do you have a view on the issue? If Congress were to ask you, they're going to say, Jack, you tell us, what do you think? And we'll follow your lead. What advice would you render to the Congress about
it? Keep the DMCA in place.
And if they said why, what would you say?
I would say it's in the long-term interests of the American people for copyright and the rights of authors, creative people, to make sure that their property is protected from the unauthorized use of that property. That's my simple answer.
Well, I am an author, and I do create things, and in fact, I just made a film, and I've never had the desire to tell people where, when, how they can view my work, and what will happen to them if they try to do something else.
If you say, I want my work to be offered to the world without compensation, may the Lord bless you, may Allah praise you, go on.
But Jack, wait, there's a big difference between saying you should have the right to exercise perfect control over the use of the content and saying you should have a right to be paid. I personally don't think that people ought to be able to get things for free in the sense of zero cost, not in Richard Stallman's view, not in the sense of free beer. That's not what's important to me. What's important to me is free in the sense of free speech, in Stallman's words, free in the sense of being able to be used in any way that the person wants to use it. Now, I think the real thrust of the question, the excellent point of the question is this perversion of the language that's going on in this debate, to call this theft. I don't think you sort of brought the biggest part of it out. What happened in the DVD case? DVDs are technologies that have a bit of code called CSS that encrypts the DVD movie so that only on authorized players can you play it. DCSS is a bit of code that cracks that encryption system. To what end? It's not as if the objective or any evidence was offered that the people who were prosecuted in this case were taking DVD movies and, quote, pirating them. They weren't distributing anything illegally. What it did was make it possible for someone with a Linux computer to take the disc and put it in their computer and play it, a disc which they presumably bought. So where's the theft in that story? Where's the pirating in that story? What's happened is Washingtonspeak has transformed people's ability to use copyrighted material in ways different from Hollywood's desire into what's so simple for everybody to understand, the American way of protecting private property, but it isn't that. That's the point. It's not theft. It's about free use of the content. And what's the complaint that you have that somebody plays this on a Linux machine?
Well, when you say Hollywood, let's understand what we're talking about. We're talking about 95,000 members of the Screen Actors Guild, 10,000 members of the Writers Guild, 9,000 members of the Directors Guild. We're talking about all the people who work in the movie industry. There are many creative people, and they believe, and I think not without some reason, that their property, in which they make a living off of, ought not be devoured or used in a way that they don't approve of. It's their property.
It's not property, Jack. It's just not property. It's not property in any sense of what we ordinarily mean, and no justification exists for protecting it as you protect your car.
Now, if
you don't have a fair use right to use my car, that's right. You have no right to get into my car and drive it around the block and say, oh, I'm just taking advantage of your car without my permission. That's what we talk about when we talk about property. Intellectual, quote, property is not that. The very same Constitution that gives Congress the power to set up, restricts Congress by saying, if Congress takes property, it must pay for the taking of the property. That's in the Constitution, the Fifth Amendment.
Right? I know about it.
The very same Constitution says Congress cannot create what you call intellectual property unless it guarantees that after a limited time it gets turned over to the public. The very same Constitution says you must turn it over to the public for limited times. Now, in the first 100 years of Congress's life, they changed the term of copyright once. And in the next 50 years, they changed it once again. In my lifetime, they've changed the term of copyright 11 times, under the limited times clause. Every time Mickey Mouse is about to fall into the public domain, magically, there's some excuse, the Europeans made us do it, for extending the term of copyright. Now, how is that consistent with this requirement?
Well, if you let me answer you, I will. I'll give you two answers. Answer number one is the word limited. Now, what do you suppose that the founding fathers put on there? If they wanted to say 14 years, they would have said it, correct? They said limited. Now, we can say that depends on what the word is, but limited time could mean 90 years or it could be 5 years. Second, and I think
1,000 years, is that a limited
well,
time?
Just pick a number. You're doing the same thing. You picked out 14.
Well, actually,
let me get my other answer to you. If you believe you're right, and you're a distinguished professor of law, and when I go to law school, I would like to have you teach me, why is it that every court that has confronted this issue takes issue with you?
Only one has, and we're appealing their decision on Thursday.
Well, I think there's several courts. Listen, if the Ninth Circuit overturns Napster, so be it. Then we'll just have to figure out something else.
But, Jack,
but right now, every court that has examined this issue from all of its aspects has taken issue with it.
In the introduction of the Copyright Term Extension Act, the Sonny Bono Copyright Term Extension Act, Mary Bono, Congressman Bono, said that you would propose the copyright term of forever minus a day. Is that limited times?
Limited means a specific amount of time. And that's what the Congress has done, Larry.
Is that a limited time, though?
I beg your pardon?
Is forever minus a day a limited time?
I said earlier that I didn't think any law is lapidary. The Constitution has been, almost 27 times has been amended. And that's what this free and loving land does from time to time.
We haven't amended this part of the Constitution yet.
No,
so I want to know, is that a limited time?
Well, I'm not clear what you're saying. I want to get back to William of Aachen. I want you to keep this simple.
I think we should put the razors away, Jack.
Okay, then. Let's just ask Ben to give us a question from the Internet. Ben, using your good judgment and your 3 screens, give us a question off the Internet from live. My Lord, you're trying to give us seizures. So Curtis Priest says, if music is so central to culture, which I believe it is, why does it need to be so expensive? After a certain level of compensation, aren't artists and producers compensated enough? Do they all need to live million-dollar lifestyles?
The answer is yes, we all need to live million-dollar lifestyles. Why not, for God? This is America.
And I guess since it's up here, why don't we just batch it with the second one, and then we'll go back to the mic. Kevin Bankston says, Professor Lessig, fair use has traditionally been treated by the courts as merely a First Amendment-derived defense against copyright infringement actions, rather than as an affirmative First Amendment right. As privately deployed rights management, hardware and software, and restrictive licenses supersede copyright laws as the primary way of protecting content, and copyright infringement actions become increasingly irrelevant, so will this defense. Will that be the end of fair use, or can you make some argument that it's a constitutional right rather than merely a defense to an infringement suit?
I believe in something called the Cohen theorem, which is you have a First Amendment right to hack any system to guarantee access to protect fair use, which means, yes, I do believe it should be able to be used as an affirmative defense to guarantee a continued balance of protection in copyright. So these technologies you were talking about, which will reduce the scope of public access and public use that copyright has traditionally created, should be able to be resisted by people, and that resistance should be upheld by courts that would attempt to prosecute them for copyright infringement.
You have any thoughts on that? Or?
I disagree.
I'm shocked. Eric, you're up.
My name is Eric Eldred. I publish online books for free. Jack, you seem to be a computer expert now. You can access my site at eldridgepress.org and read all these books for free. And I'm offering them and authorizing you to be able to do that. The books are generally in the public domain, but many of them are copyrighted because I secured the right to do that. And I also have permission from copyright owners in cases where perhaps the books have been out of print and this is the only way for them to be accessible. But I don't want to talk about the case because Larry Lessig is going to be arguing very eloquently in the appeals court for that this week. I do want to ask you something about the harmonization that you say was the purpose for the Copyright Term Extension Act, right? Harmonization of copyright law in the United States with that in Europe. Right. Well, in the 18th century, the 19th century, I'm not too sure exactly when, two songwriters sat down at a cafe on the Champs-Élysées, I believe, and they heard one of their songs being played by the orchestra. And so they called the manager over and asked him if there was some reason why they were not paying for this, because if it were published in a sheet music, then they would have to pay for it. But if it were simply played by the orchestra, there was no law that allowed the authors of the song to be reimbursed, right? So the manager refused to pay them for it because he said it wasn't required by the law, and so they refused to pay for their meal. And they were sent to jail, and people were so outraged that the French law then was changed so that there would be royalties paid for public performances of music. You agree with that? Is that stealing when that's actually performed in a public place, music that somebody's written?
Well, you're talking about ASCAP and BMI now.
No. I'm saying Charlie took you to a nice restaurant this evening, right? Yes or no?
No.
Right, yes or no? Okay. Did you like the meal?
I don't know enough about the contracts at BMI.
No. It's not that. It's the law. Okay. In the United States, when the Copyright Term Extension Act was passed, it had a provision specifically allowing the owners of bars and restaurants not to have to pay royalties for the performance of music. Is that correct? You remember that? That was one of the provisions in the law. Without it, it would never have been passed. There was bargaining between two economic interests. Is that correct?
I remember there was a little
right.
fight.
Now, do you think that stealing, okay, if you're in a nice restaurant here in Cambridge...
Am I on trial here?
Is it stealing or not? Tell me, what do you think?
I want my lawyer to stand up and say, I object.
No. I mean, let's pretend that you have some artistic talent and that you're like Sonny Bono and that you could write a song and the song is being, recorded and playing over the thing. I'm serious.
The answer is you're talking about music, and that's not my turf. You want to talk about movies, I'll be glad to do it with you.
But, okay, suppose that instead of movies, the law had exempted, instead of music, it had exempted movies from bars and restaurants from paying for movies. Would you think that would be stealing?
I would think anybody that tried to see a movie without paying for it or without having the permission of the owner is obviously doing something that's naughty.
Right, even though the Copyright Term Extension Act might have...
It's in the public domain, you mean?
No.
If the law says you can do it, is it stealing?
If the law says you can do it, I'm not going to break the law.
Right. Well, I think next year, according to the New York Times today, you're going to be confronted with a bunch of artists who claim to be authors of the works. And they're going to say that they need to be recompensed according to the copyright law for their works, all right? They're going to go on strike, and then the movie studios will have to defend their economic interests against the actual authors. If you remember, back in the copyright clause itself, the limited rights were extended to who? Authors and inventors, right?
All I'm saying is if it's against the law, shouldn't do it. If it's the law, we do it.
Right, but see, beyond the law, there's some principles involved, okay? You talked about Kant. You talked about, this intellectual property theory of natural rights, okay? But in Kant and in this natural rights theory, there's no provision for a limited term. It goes on forever. It's a perpetual right, all right? Is that what you're claiming?
Well, when you talk, you're using the European version of the auteur theory, which is called droit moral, which is the moral rights, which we don't have in this country.
Well, we have some of them, but is that what you want?
No, I don't want the moral
No,
rights.
because that only applies
Give
to
the guy
the
a chance
office.
to answer.
Well, Eric, I mean, I'm not indicted yet, for God's sakes. Don't interrogate me like this. The answer is I'm opposed to the European system of morale, or the moral rights, because I think that's not consistent with what we in America do. And by the way, whatever the Europeans want to do, that is their sovereign right to do it. I have no problem with that. And we've got a sovereign right in this country to deal with it in a different way. We call it works for hire in the movie business. Period. End of paragraph.
Larry, any thought before we... Ben, do we have another online comment you want to share, or should we go back to the microphone? Back to the microphone.
Hi, I'm Walter McDonough. I'm one of the founding board members of the Future Music Coalition in Washington, D.C. And since you like precedent, and you like Judge Patel, in her ruling in the Napster case, I have to call your attention to a ruling the year before where, in a similar case to Emmanuel, she ruled that there's actual free speech rights in source code. So different judges in the United States have differed on this issue, and I believe that, thanks to Professor Nessen's work, the Second Circuit will overturn that case. And this is a point I want to make. I agree with you in a lot. I work in the entertainment industry myself and have for a long time. I love the business, as I'm sure you do. But there's a question I have to pose, and it's really more of an ethical, moral, and political question than it is a legal question, and that is this. Can your efforts to enforce your rights have negative consequences for everybody else? I'll give you two specific examples. Judge Kaplan, in Emmanuel's case, said, and I'm interpreting this, but my take on it is that he said that there's basically an exception to the First Amendment in copyright infringement cases, which is something that our legal history completely rejects. The second thing that I think is very unfortunate and something we're going to fight next year at the Congress, and probably going to fight against you, I don't know. But traditionally in our country, we have always had a notion of fair use, whether it's for Harvard Law School or for the elementary school down the street from my house. And with the proliferation of SDMI and the type of security devices you're going to try to circumvent the copyright code through technology, so this traditional right that we've had for our entire history of Americans, we have for our teachers, for our kids, is going to be taken away. So the question I pose is, do you believe there can be detrimental aspects when you try to enforce your rights as a copy holder? And B, do you think that our traditional notions of fair use should be violated for the benefit of the entertainment industry?
I don't know of any detrimental effects that come from the protection of one's intellectual property.
May I give you an example?
I beg your pardon?
May I give you an example?
Of course you can.
Well, I just
It's a
spoke
free
about...
country.
Well, not if we have Judge Kaplan's case, because he's saying that there's an exception to the First Amendment. I mean, clearly it's going to be overturned.
Well, I think Judge Oliver Wendell Holmes said there was an exception to the First Amendment. You can't yell fire in a crowded theater.
He's not yelling fire.
But this has nothing to do with free speech.
That's what
And
Judge
by the way, on the DMCA, all the libraries in this country and all the universities in this country all signed off on the aspects of fair use within that DMCA. Are you aware of that?
And I'm also aware right now that a lot of the librarians associations want to go back to the Congress and protect their rights against things like SDMI.
I only know is the Library Association, representing all the libraries in this country, and I might add all the universities, were deeply involved in the construction of the language, in the shape and form of the legislative complexion of that bill, and everything that they wanted, they signed off on it with Senator Hatch. I was there when they did it.
Okay, well, they have a contrary position on this because they do not believe that the entertainment industry should be able to lock it up with a technological key and prevent them from bringing music or film into the classrooms as they've been able to do since the founding of our country.
You can, in your classroom right now, show any movie you want. Go to Blockbuster, and you can get any movie in the world except the ones actually playing in theaters. And by the way, every library, you can go and rent. You can take out a DVD. You can take out a video cassette. They're there in the library. Anything you want, just except the movies that are actually showing in the theaters. But you mean the library can't wait for, say, 1 month or 2 months before it comes out in video or DVD form? Of course they can.
Let me say one final thing. 5 years from now, as you're building the catalog and you lock it up with a technological key, that may not be the case in 15 years.
Well, I'm not aware that we're doing any locking, but maybe you...
Maybe we can narrow this disagreement a bit, Jack. I mean, I think the questions the thrust of the question is, we've had a tradition protecting fair use. And you agree, you support fair use, right?
I absolutely do.
Okay. Let's imagine it becomes the case that technology takes away fair use rights. Would you oppose that
Technology takes away fair use?
Yeah.
I am for fair use.
Okay, so would you oppose...
But it is the definition of fair use, Larry, I think that's the key here. Everything has to be defined, particularly in law.
Mm-hmm. Right, so we could have that boring law game of defining it particularly right now, but whatever it is, if technology reduces it, would you oppose that technology?
I don't have any idea what you're talking about.
Well,
if you just give me an example, I'd be glad to answer it.
Fine. Fair use is ordinarily understood to be including the ability to take and copy a certain portion of a copyrighted work, regardless of the author's...
To use in a classroom?
For example.
Absolutely. That's fair use, and I have no problem with that.
Okay. Let's say the technology makes it impossible for you to copy it, and expressly says that you're not allowed to use it except for the following use: to sit as a couch potato watching it at home. That's what it says.
But you
the license says, and the technology makes it...
That's not fair use to me.
I know that's not fair use.
Fair use is being able to show Spartacus or Erin Brockovich, which is a brand new movie, in your classroom if you want to talk about that. And by the way, if you want to show it in the library, that's fine too. You have it to be able for people to take out and take home and bring back to the library. Right. That's fair use.
Right. But if the technology made it so that you could not exercise fair use, you could not copy a section of it, for example, which is ordinarily...
I'm opposed to that.
You're opposed to that technology?
Yes, I am.
Okay.
That's unauthorized, and that's the whole key to this thing. And I don't understand why the simple urgings of a simple sentence is not getting through, and that is, you cannot use a piece of intellectual property that you have not gotten permission to use, or you haven't paid fair compensation for the use of it. Now, what is so ambiguous about that?